Happy New Year to everyone. A warm welcome and good afternoon to our distinguished guests, honorable judges, moderators and speakers. Our attendees attending in person at AIAC Auditorium and virtually on Zoom. My name is Azlan Jaiz and I will be your virtual MC for today. We are excited to see all of you in our very first hybrid event this year, the Standard Form of Building Contracts Forum 2022, jointly organized by Legal Plus and L2 Icon in conjunction with a book launch by LexisNexis Malaysia. It is our honor to celebrate the launch of Standard Form of Building Contracts Compact, a book authored by Datuk Professor Sundra Rajoo. Congratulations, Datuk. Before I proceed, I would like to remind everyone in the auditorium to observe some rules and SOPs for everyone's well-being. Number 1, please wear your face mask at all times. Number 2, please ensure 1 meter social distancing. Number 3, please avoid physical contact such as handshake, fist bump, and etc. And number 4, please avoid overcrowding. So ladies and gentlemen, the first part of our event, which is the book launch, will be live streamed to LinkedIn and Facebook, followed by the forum. The forum is a private event and will not be live streamed to our social media platforms. If you are watching us now on LinkedIn and Facebook, quickly get yourself registered for our virtual pass online. Also, our forum's hybrid pass and virtual pass attendees who stay till the end of our forum stand a chance of winning a copy of the Standard Form of Building Contracts Compact authored by Datuk Sundra. So please do not go away. I also wish to take this opportunity to thank our supporting organizations for today's event. Master Builders Association Malaysia, MBAM, Chartered Institute of Arbitrators Malaysia, CIARB, Malaysian Institute of Arbitrators, MIARB, ASEAN Institute of Alternative Dispute Resolution, AIADR, Chartered Association of Building Engineers, CABE, Chartered Institute of Building, CIOB, Women in Construction Malaysia, WIBM, and last but not least, Lighthouse Club of Kuala Lumpur, LHCKL. We are truly honored to have their support, which certainly adds to the prestige of this event. Without further ado, let me hand over the session to our event MCs at the auditorium. Over to you, Heather and Kaijun. Ladies and gentlemen, I will see you in the auditorium in person shortly.
Thank you so much, our virtual MC, Mr. Azlan. A very good afternoon to honorable delegates, esteemed speakers, distinguished guests, and participants joining from different corners of the world. My name is Heather Yijingwa. Together with me is Mr. Lee Kaijun. We will be your MCs for the event.
To formally take off our events this morning, it is with my great pleasure to invite Yang Ahmad Arif, Tun's Datuk Seri Dr. Zaki bin Tun Asmi to deliver his opening remarks. As a brief introduction, Tun Asmi is currently the Chief Justice of International Financial Centre Dubai, retired Chief Justice of Malaysia and the Chairman of Legal Plus.
Ladies and gentlemen, this is my umpteenth take of this video. I'm trying to work on it alone, by myself. If it doesn't work, this is the last time. I'm not going to do it again. Ladies and gentlemen, thank you very much for being patient. This video is to welcome you to the hybrid event which is organized by Legal Plus and L2 Icon. This is the first time we're doing it. And the purpose of having this event is A, to launch a book by Datuk Sundra Rajoo, and 2, to be followed by a forum to Datuk Sundra Rajoo and LexisNexis. I congratulate you for the launch of this book. Datuk, I'm sure this book will be very useful to legal practitioners and engineers whose work relates to building contracts. So well done. And this is going to be followed by a forum to discuss the very topic of the book. That is the differences and the similarities of the different standard building contracts that we use. For this forum, we have invited 12 panelists and 2 moderators. I say thank you to the panelists and moderators. And with that, I bid you farewell. Thank you very much.
Thank you so much, Yang Ahmad Arif, for the wonderful welcoming speech. First of all, we would like to congratulate the author of the book entitled Standard Form of Building Contracts Compared, Datuk Professor Sundra Rajoo, and would like to invite Datuk Professor Sundra to have a few words. Let us give a round of applause.
Datuk Professor Sundra Rajoo needs no introductions. Datuk Professor has tertiary qualifications and professional registrations, covering every phase of the development, planning, architecture, construction law, and arbitrations. He has authored, co-authored, edited 10 books and arbitrations, adjudications, contract, and construction law. I will now pass the stage to Datuk Professor Sundra Rajoo. Datuk.
Thank you so much, honorable judges, distinguished guests, ladies and gentlemen. A very good afternoon to all of you all in person and virtually. Today is the first time in 3 years that I'm on this podium. The last time was in October 2018. It's quite poignant for me, and it feels quite good. Thank you very much. The years 2020 and 2021 has been quite productive for me, in that I was able to author 2 books. The first book, 1,928 pages, is entitled Law, Practice and Procedure of Arbitration in India, as published by Thomson Reuters India in November 2021. That is about 2.5 months ago. Because I was working concurrently with 2 different teams. And then the second book, which is this book, at 2,400 pages, the publisher said absolute no more. 2,400 is the absolute stop to this book. And in 2 volumes, we had to split it in 2 volumes. And it's entitled Standard Form Building Contracts Compared. It is published by LexisNexis. It's good to work again with LexisNexis. And it's being launched today. The debts I owe in writing these books are enormous, and many of people are not named. But in particular, I want to state how grateful I am to my family, who have always been there for me. My wife, Vanita, and my daughter are present today. Thank you very much for being here. I thank the joint organizers, L2 Icon, Legal Plus, and LexisNexis for this launch event, and also for the successful conduct of this hybrid event in 2022. In particular, I want to state my appreciation for Mr. Leong Hong Kit and Miss Cindy Wong, together with their team, it's a dream team, for their tremendous effort in organizing this event. I must confess, and I have to actually declare, that Leong Hong Kit and Cindy Wong are co-authors as we continue our work on the law, practice, and procedure of adjudication, which is due for completion in the first part of this year. So they are very, very committed to the cause, and I'm so grateful for it. I have received kindness from the luminaries who have contributed forwards to this book, particularly Young Arif, Datuk Lim Chong Fong, High Court Judge, Young Arif, Datuk Mary Lim Tien Swan, Federal Court Judge, and Mr. Chow Kok Fong of Singapore. I think there's a history behind it because Datuk Mary Lim, Young Arif Datuk Mary Lim was the first construction judge in KL. So I think that's historical, and currently Young Arif Datuk Lim Chong Fong is the construction judge in KL. So, and my relationship with them go away a long time. So I'm very appreciative. I think you can see that detail when we discuss it in the book. Both of them are present. Thank you for being here, both of you all. I'm very, very grateful for that. Ladies and gentlemen, let me begin with a little background on how this book was written. It all started with my experience on contributing to standard form building contracts, particularly in Malaysia. In 1997, that was about 24, 25 years ago, I was commissioned by the Malaysian Institute of Architects to complete the successful PAM 1998 form, which replaced the old PAM ISM 1969. Now, subsequently, in 2018, I was director of KLRCA, and thereafter AIAC. We conceptualized, and I led an expert advisory committee with, I think, Mr. Lam Wai Lun, who's here, as deputy chair, to draft and offer a standard form contract now known as the AIAC form of building contract. Originally, this book, in its early incarnation in 2020, was to be a commentary on the PAM Form 2018. I sought to co-author the book at that time with IR Harban Singh, KS, and also Mr. Lam Wai Lun. The manuscript actually progressed at snail's pace, and our enthusiasm waned. So I decided then to abandon writing a book on the PAM Form 2018 and focused my effort on the law, practice, and procedure of arbitration in India. Thereafter, I completed the main work somewhere in May 2021 with a team of young, talented, energetic, just like what I have now, young Indian lawyers. That is an eye-opener for me. And then I came back to the book. When I came back to the book, I said that this PAM 2018 form is not going to work. So I restructured the book and basically decided that we will do a comparative approach of the book by way of identifying domestic forms and international forms so that there could be a coherence in the narrative. Now, it became a totally new book. We completed the book, you will never believe it, in 8 months with intensive research, writing, scrutiny, and the manuscript, I must say, we delivered progressively. I think people, a lot, my team suffered. I'll identify the team. And it was completed last month on the 7th of December. So I think it is quite amazing that we are here today. And I've included actually Harban Singh and also Lam Wai Lun as special contributors because to recognize their earlier commitment to the PAM Form 2018 book, which did not materialize. But I think more importantly is their continued support that I got from them after that, and I have to recognize that. So they are there. But the real people that I want to be acknowledged is I'm really indebted to this, again, young, energetic, talented lawyers in Malaysia. All of them are Malaysian. And I call them nominally the editorial board. You will see in the book that you have a photograph and you have a CV of them. And I want to actually ask you to stand up as I call out a name. First is Ng Chu Yin, who is also a qualified quantity surveyor, Ng Chuin. Then Heather E. Jinwa, who's our MC. Then Lee Kai-jun, who's also our MC. Then we have Naveen. Naveen is there, Naveen. And then we have Leong Chi Weng, tall man, Naveen. And this is the first time I'm meeting them, by the way. This is the first time today I'm meeting the editorial team physically. So, and then we have Samira Hassan. Samira is there, working for Kevin. And then James Ding, of course we are James Ding, everybody knows James Ding, is it? then we have Ashley Uy. And then Ankit, is Ankit here? I don't see Ankit. No, I must say that this is the real team that did the work. The research, the first draft, the hard work, and particularly Ng Chuin. Ng Chuin, I think, I really believe she found herself. That she suddenly realized that she is actually a very capable person. And she is able to do, she worked very hard, she did extra, and then we made sure the final manuscript is finished with Heather also. So I'm very, very indebted to the editorial team. Thank you so much. My gratitude actually extends also to the team in LexisNexis. Devi is here, Shuhashini is here, I see Asha, Jasmine, Chloe. They drove a hard bargain. I still remember Heather was joining, later Chuin was joining in to the deciding the contract, and they said the manuscript must come in October, and we compromised, I think, to November. But we delivered. We delivered by, I think we were 7 days late. But I think also, I believe that that gave a breather to the editorial team. Jasmine was having a really horrid time. She was, I think, working through the weekends and all these things. So I'm very, very grateful for the support. Ladies and gentlemen, I want to talk about a little bit about the book. The book, the plan is to provide a compendium on construction law as is practiced in standard form building contracts. And it's set out in 4 divisions. Now, Division 1 is basically a historical and also a discussion of the various standard form of contracts that are being looked at, and also the international forms. I chose 2 international forms and 6 local forms to give you an overreach. So that Division 1 just talks about how these forms evolve and what are the issues in regards to those forms and how they are continuing to change and how they are being used. The Division 2 was the real meat that is starting, where we compared the forms. And we compare the forms done in a different way. We compare the forms done by subject area. For example, okay, let me tell you what are the forms that we did. We used the PAM for 2018 form as the core. Then we had the AIAC form 2019, the PWD 203A, IEM 2017, CIDB 2000, the FIDIC rate book 2017, and the JCT 2016. And what we did was we took subject areas, contractual contractor's obligation, materials and goods, variations, practical completion, defects liability, damages for non-completion, extension of time, loss and expense, payments, arbitration, and performance bond, and analyzed on an overall basis all the clauses, how they are working. Actually, the clauses are not important. It's how the method, or let's say payment, works generally in standard forms. And then we bring in examples. The Division 3 is the real detailed commentary. We use the PAM form, 40 clauses in the PAM form, and each of the 40 clauses were analyzed in great detail, some of it going to maybe about 60, 70 pages, some of them 100 pages, particularly extension of time is 100 over pages. And we went in great detail, showing a similar provision on the various forms, how they deal with it. So I think once you see that, there you can see the meat. And finally, we have Division 4. Division 4 is all those clause provisions that are all in the other standard forms that are not in the PAM form. So I think in one go, we have explored the entire gamut of possible provisions that are found in standard forms. So I think we really hope, I mean, I'm quite sure the editorial team joins me with this, that it will guide users and then answer some questions that are important that rise in the course of selecting and using and implementing standard forms. And I hope the book will be instructive. I think more importantly, it should stimulate debate and dialogue. As a concluding remark, I again take this opportunity to commend once again the joint organizers, L2 Icon, Legal Plus, and LexisNexis for coming together and promoting this standard form buildings contracts forum. I wish a great success for this forum. Thank you so much, all of y'all, for being here in person and also virtually. I really appreciate it. Thank you so much.
Thank you so much, Datuk Professor Sundra Rajoo, for the wonderful speech. Datuk, please remain on the stage. We will be having a dialogue session. We will now invite the forward writers of the book, Justice Datuk Mary Lim Tien Xuan, Justice Datuk Lim Chong Fong, and the representative of the editorial board of the book, Ms. Ng Chung Ying, to the stage. Let us welcome.
Previously mentioned, Justice Datuk Mary Lim is the sitting judge of the Federal Courts, and she was the first judge of the Constructions Court in Kuala Lumpur. Justice Datuk Lim Chong Fong is the sitting judge of the High Courts of Kuala Lumpur Constructions Divisions. We are regrets to inform that the forwards writers Professor Chow Kok Fong and the special contributors IR Harban Singh, who both have contributed greatly to the books, are unable to join us today. On the other hand, the moderators, Ms. Ng Chu Yin, is an advocate and solicitor and currently practices in Messrs. Asman Davison and Co. in the areas of constructions, engineering, and infrastructures. Prior to her legal career, she is a UK Chartered Quantity Surveyor and a Consultant Quantity Surveyor of Boards of Quantity Surveyor Malaysia. Let us give a big applause to welcome them. Chu Yin, the floor is yours.
Thank you very much, Kai Jun and Heather. Good afternoon, distinguished guests, ladies and gentlemen. Welcome to this afternoon dialogue session surrounding Datuk Sundra Rajoo's latest book, Standard Form of Building Contracts. And as today's title suggests, what we will be exploring today is the subject matter of Datuk's latest book, Standard Form of Contracts. And to do so, I'm joined by three wonderful and highly respectable people. I'll start with Datuk Sundra Rajoo, who is the author of the book, and as well as two judges, and they are also the forward writer of Datuk Sundra Rajoo's book, Standard Form of Building Contracts Compared. They are Justice Mary Lim and Justice Lim Chong Fong. They will be sharing their insights with us and all the audience today. And they actually don't need any introduction. They are legendary and highly remarkable, and I'm truly honored to have this dialogue session together with them. And this dialogue session will be quite short, around 20 to 25 minutes. And without further ado, let's start with the first question. I would like to pose the first question to Justice Mary Lim. Judge, as a comparison between the standard form of contract and also the bespoke contract, what are the general issues that you commonly see as a judge for all the large and very complex construction projects? Over to you.
Oh, thank you very much, and good afternoon. Can I, before answering the question, seize this opportunity? Happy New Year, everybody. It's so wonderful to see each one of you here safe. I guess you're here because you've done your tests like me, and we're all safe and sound. Second, I want to congratulate Datuk Sundra and Datin Vanita, because he couldn't have done it without her, as he has admitted it. And finally, well, when Datuk Sundra asked me to write this forward, I didn't know there was a price to pay, that I had to then get involved in a dialogue and explain myself, because I thought I've already explained whatever I had to explain, and I guess it's because you guys haven't bought the book which you ought to have done, and then it would have explained itself. Now, what was the question? Right. The question is about these bespoke contracts and standard form of contracts. What are the general issues that arise for large contracts? I think the problems that arise, I think first of all, the issue is choosing whether you want a bespoke or a standard form. And I think the size of the contract doesn't really dictate that. I think it's the client's choice. And the clients have been in the market for so long, they make very conscious decisions on what kind of contracts they want. And I think it also depends on whether they have an in-house legal team. And if they have an in-house legal team in some of these large contracts, they would have a practice, a particular style that they would have had. And therefore, they would have their shelves of contracts to pull out from, and there are hordes of experience as to which would work. And depending on the kind of project, they then make that conscious choice between taking a standard form contract and bespoking it to their particular conditions, or use one that has worked well. From my experience, it's not the size of the contract that dictates it. I think it's very much it depends on the employer whose contract it is. And very often, if you see the government contracts, there isn't very much of a choice. It's this or nothing at all. Is that bespoke? Well, I think the JKR people would say that's bespoke for them. And that's what it is. It's become a standard form, but it's bespoke insofar as the government is concerned. What are the issues that are faced? I think sometimes when it is bespoke, it is still not good enough in the sense that it doesn't cover what it's supposed to cover. It only deals with what you think are the essential terms. But in my understanding from the practice, from the cases that we've seen, I think the problem is not implementing the clauses, regardless whether it is in a bespoke contract or in a standard form of contract. It's the implementation of it and the execution of it by the contract administrator, not following the terms there. That, to me, is usually the problem. The terms are there. I hope that answers your question.
Yeah, of course. I agree with Justice Marilyn that in the large and complex construction project, they usually have a big legal team. But in catching on that point, I would like to pose the second question to Justice Lim because some of the smaller size contractors or smaller projects, they may not have the luxury of the legal team. And I've actually done some research on, according to the Department of Statistics Malaysia, the construction of the small trade activities actually increased by 75% in the second quarter of last year, 2021. So in your experience, Dato', why is it relevant, do you think, for all the smaller contracts to use a proper standard form of contract? Or do you think, is it necessary for them to use the standard form of contract? Over to you.
Right. Thank you, Juin. Happy New Year 2022 to all of you. Now, I have seen the book for the first time, actually yesterday. Although when I wrote the foreword, I had seen parts of the manuscript. Certainly, it has been an excellent mammoth task, and I must congratulate all the writers, particularly Datuk Sundra Rajoo and the editorial board. Job well done. Now, coming to the question, minor works. Well, I think one has to look at whether the contract is meant for main contracts. As you know, most main contracting work also have been subcontracted out. So the question is, minor works, is it for main contract or subcontracts? For main contracts, there are few standard forms available. I think the most recent one is the PAM minor works available. And I suppose the question of minor is, I think, largely that probably from the perspective of the price of the works, probably below 100,000 ringgit, perhaps, is considered minor. But nowadays, you actually can't do much with 100,000 ringgit too, maybe refurbishment. You want to build a bungalow, maybe easily 2 million ringgit now. So it depends on the project as well. I think from what I have gone through over the years, construction law, most main contracts are based on standard forms. Subcontracts, the nominated subcontracts are also based on standard forms. The domestic subcontracts are usually bespoke forms of the main contracting organization. And some have in-house drawn up conditions of contract. Others are maybe just letters of award. So if you have a standard form, then of course you probably can expect a comprehensive set of contractual provisions and allocations. If you don't, if let's say you operate on a bespoke letter of award, then it's likely to be very rudimentary. Then there will have to be perhaps implied terms when a dispute ensues and has to be interpreted by an arbitrator or by the court. And I think the one common problem, of course, as you know, in most projects, I have not heard of any actually having been completed on the original time. So there will invariably be delays. And if you are on a simple letter of award, then of course you all would appreciate the concept of time at large, especially when problems happen. So there is no mechanism. So if any extension of time, probably it has to be by agreement. And then if there's an LED clause, which is more common than EOT clause, so with an LED without an EOT clause, it doesn't work as well. So in that respect, then perhaps the minor work form may be the best fit in between having a full standard form or a letter of award in a minor work scenario. That's my short answer.
Okay, thank you, Justice Lim Chong Fong. And catching up on what Justice Lim has just mentioned about most of the main contracts, they are using standard form of contract. So on that note, I would like to pose the next question to Datuk Sundra Rajoo. Datuk Sundra, would you like to share with us what are the advantages of using the standard form of building contracts as compared to some of the bespoke contracts?
Thank you, Chuin. The main problem with the bespoke contracts is basically, are you going to start from zero and start drafting? Because it's normally, first thing is that you do a bespoke contract, normally either you're totally ignorant about contracts, or you are a very, very big client, a developer who has a lot of your own type of projects. Then you say that I want to do a project that fits my kind of requirements. Would be normally financial arrangements, it could be special requirements. Even the project itself could be a special project. You know, I was on a panel, Society of Construction Law in India, and we were talking about special terms. And they were talking about tunneling projects. Tunneling projects, originally, they did not have a standard form contract. So when you do not have a standard form contract, you have to do a bespoke form. So, but again, who do you get to draft that contract? So do you get a lawyer? Do you get an engineer? Or do you get a team? So then I think this is the main, and then after that, the cost part comes in. Because when you get a team like that, somebody is going to have to be paid for their time, for their, for their effort. And again, you know, you can never be sure unless somebody again audits that form. So you can see what the problems with bespoke contracts will be. Now, what is standard form contract? Standard form contracts is something that we all quite familiar with. It is out there in the market. It is published. They have core arrangements, core responsibilities, core obligations. All the things are generally covered. So as such, the real problem with bespoke forms is it is hardly used nowadays. In Malaysia, at least I can say, I think, like I give you one client that actually tried to do bespoke forms, Putrajaya. They were building an entire city and very, very large buildings. So they decided to do their own form, but it really didn't take off after that. It just stopped there with, I mean, they are using it, but it is for their own special requirements. But again, you will see many of the bespoke forms will always go back and use a standard form as the base. So that is why I think, that's the main difference I think you should think about when you are using, deciding to do a bespoke form. You may actually look around and see whether there is a standard form which you can modify for your particular requirement. So I think that is the approach that is normally taken. Thank you, Chuin.
Thank you, Datuk. Thank you, Datuk Sundra. And for the next question, I'm going to pose it to Justice Lim Chong Fong. And there are a lot of comments about standard form of contracts and link it to the contract and fair and balanced contract. Do you think that it is important to have a fair and balanced contract? Or what are the common issues that you usually see as a previously practitioners and as a judge that are faced by the parties when the contract terms are very onerous?
Right, it's ideal to have a fair contract, fair to both parties. My experience, I see many construction contracts tend to be lopsided. So the bulk of the risk usually is transferred over to the contractor. But as you all know, as a matter of general law, as far as construction contracts are concerned, there is no legislative intervention like the Unfair Contract Terms Act, for example, in the UK. In Malaysia, we have imported that act only in consumer contracts, in our Consumer Protection Act. So, but construction contracts are unfortunately not captured within the Consumer Protection Act. So every contract then have to be construed based on what the conditions of contract provide. So I think the question then becomes, there is a commercial aspect to it and a legal aspect to it. As far as the commercial aspect, it's quite clear that if the risks are substantially transferred to the contractor, then one would say the contractor should price for it, and in theory, it will carry a higher price. Hopefully, all the risks are covered. But as you all would know, by reason of the competitive tendering, and everybody needs to get and to secure the contract, the pricing normally does not cover the risk. So when the risk eventuates, then problems will come. Disputes will come over, and dispute resolution becomes necessary. So as far as the legal aspects are concerned, I think from what I can see from the standard forms, especially the main contract standard forms, I see, including in the PAM form 2018, increasing provisions of conditions precedent. I think it started with the earlier 2006 form, and then of course maybe borrowed, the idea was borrowed from the PWD 203 forms. And of course, it has been judicially decided earlier by Justice Lee Si Seng in Sunisa and Kerajaan Malaysia. And then more recently, I decided in Eco City versus Taxing Engineering. It will be given effect. So I think many contractors are not prepared or not ready, perhaps, to handle conditions precedent. So a lot of good claims, unfortunately, cannot succeed if met. So this is something I think contractors got to be very vigilant. And a strong contract administration team is required during the administration of the contract. Otherwise, it's too late when it comes to me or to any other arbitrator. I think that's the advice I'd like to give as far as this is concerned.
Thank you, Justice Lim. I have a personal experience as well. The contractor is well aware of the risk in the contract, but they do not want to price in the risk. And then they decided to price lower, but the other tenderers, they price higher with the risk, and they didn't got the job. So at the end, the contractor suffer and bring into disputes. So that actually brings us to the next question to Justice Mary Lim. In your foreword in Datuk Sundra's book, you have actually mentioned about understanding the contractual arrangement, and the interplay of the contractor arrangement must be properly addressed from the start of the project. In your experience, what are the common issues that arise due to the lack of understanding of such practice?
Thanks very much, Jay. That actually just brings me right follow up to my learned brother's comments about and response to your question about fairness and balance terms in a construction contract. I actually think that if you signed on the dotted line, you signed because that's fair. And you've worked your price, you've worked your risks, and you've made a decision whether it's going to sign and it's all in there and your margins are all worked out, or you're going to take that risk that I'm going to sign and fight later and see how much my risks are going to be eaten up by arguments. So I actually don't see it as being unfair at all. Once you've signed, there's no issue of fairness. I've yet to see in a long time a contract being approached and vitiated on the ground that there's been unfairness in its dealings, that somebody held a gun to so-and-so's head and made him sign. So I don't see that as an unfairness. The moment you've signed, that's it. So, and because of that, you need to work your margins, your risks right at the upfront. You need to understand that whichever contract you're going to use to sign and to get whoever it is to sign on your behalf, including your nominee, that the margins have already been decided, and that you don't, and that you know how it's going to work. I think it's very difficult to cry over spilt milk, and that's very much often the case. And it brings us back to the book that is being launched today. Whether it's a bespoke contract that you're going to sit down and design yourself, or whether it's a standard form type of contract, you must make a conscious decision and an acceptance that it encompasses everything you want and you're prepared to risk. And that you made a choice. And it all comes down to the profit margin. In my experience, the greatest problems that are faced are, even in those standard form of contracts, there are missing express terms. And that's the reality of it, that we then turn to what my learned brothers just said. We turn to implied terms to try and see what really was the intention of the parties at the outset, to see if this is how they want to work. And the devil, as they say, is always in the details. When you pick a bespoke contract, we start to design a contract. And this, I'm going to borrow words of the late Justice Yusofi Abdul Qadir when he was talking about somebody's submissions, that he had, you've taken a serpent's tail and a dragon's head, and the two just don't mix. So and this was actually something that we faced. Somebody had taken bits of standard form contracts, put it together as their bespoke contract. And it was so difficult to work out exactly what the timelines were, because timelines and obligations tick differently depending on which arrangements you use. So, but if you are prepared to sign on that bottom line, it actually is, to me, a conscious decision that never mind the lawyers have just done anything that they can put together, I'm going to sign it, because at the end of the day, I'm going to see that contract performed, and that I'm going to collect, and I've got this margin of error. The problem is, back to the point I made, contract administration. The project is not well administered. And very often, regretfully, I don't see the decision makers taking charge. I don't know why, when you have to make decisions on time extensions, when you have to make decisions on whether you are going to agree that this is a variation, whether you're going to issue that order, people drag their feet, and they drag. And that's where the problem starts. So, to me, these are the common areas, not sticking to the letter and not sticking to the intent. If the intent at the beginning, and it really can be the case, that whatever's in that document doesn't really matter, then stick by it. Those are usually the problems I find.
Thank you, Justice Mary Lim. And for the next question is actually also touching on the similar point that Justice Mary Lim has just mentioned about sticking it to the words of the contracts. That's the most difficult part, and the common issues are actually the contract administration part. So, Datuk Sundra, from a practitioner point of view, what are the ways that the parties can do to reduce those lack of understanding or the lack of contract administrative errors, in your view?
I think first read the contract. To go down to basic. It's actually fascinating. I graduated in 1979, and when my training in contract, I think was superficial. Because I did a HBP degree, and I still remember the amount of academic training that I got on contract, construction contract, although we were doing a construction course, was quite basic. So, that's, I think, where the real problem is. The lack of understanding comes out from not knowing, first, basic rules relating to construction contracts. Two, basic roles that are set out in construction contracts. We tend to assume that these are the rules that an architect is supposed to do. You see, there are different professions. Our system is still very, very segmented. This is, I see it as a problem. In fact, I think when we look at the system as it is, the architect says, I will design the job. And then he also tries to, or she tries to actually administer the contract. And there are certain things that are put out in the contract. Then you have the quantity surveyor says, I actually do the measurements and I will do the valuation. And then you have the engineer. So the consulting team becomes quite important, because basically then you have the person who actually builds it. And then he has the subs who are also building it. And all of them are tied together by various contracts. Some are main contract, some are subcontracts, some are basically quotations. So what really somebody has to do is that the real problem is when people misunderstand terms, what they are supposed to do, or they do not deliver. In fact, failure in delivery coming out from a contract gives rise to disputes, really, for me. All the rest is, as Datuk Yang Arif, Datuk Lim put it, is that he has not seen a contract that finishes on time. Just look at that. But we are very, very clear there's a completion date. There's a completion date. You must deliver by that date. And then there are various rules. The presumption, again, is the person who administers the contract knows the contract. And it's also a presumption the person who's actually using working on the contract, the contractor also knows the contract. But when both don't know the contract, then they go to a third party when they have a dispute. This is where the interesting part is. A lot of post-mortem goes on. And then they say, hey, you should have had this, you should have had that, you should have done this, you should have done that. There's a dispute. And then we go to another third party to resolve the dispute. And it's an adversarial system in our place. You have to present the best case that you have, both sides. So again, you know, I think for me the basic thing is that we have to go back now to our training system. First is that the courses itself, the fundamental courses dealing in the construction industry must have core subjects dealing with construction contract law and construction contracts. That means it must be, but it can be done. It can be done, you know, because now it's mostly it's elective or it's very basic, you know. And then I think in, you know, even lawyers, you know, our core subjects when we first train, it doesn't have construction law. We just learn contract, you know, and tort, and we tie contract tort, and then some people will do planning law. We do other kinds of specialized, even liens and all these things, which are basically things that are specialized laws from other fields, you know, and then it comes back together. But somehow or other, I think that if you want to go into the construction industry, we must make it a rule that you must know basic construction law. And then beyond that, if you want to be in an advisory role, you want to manage it, then you must have a higher level. If you are into dispute, you just cannot go to, in fact, I think this is where the specialization is coming in. Understanding is by specializing. The future is about that. I think the first thing we must also recognize, because so much money is involved, so much emotion and passion in trying to get something up, that it is actually the time for the amateur is over. You know, seriously. I mean, I really believe it. The time for the amateur, that, you know, that's why we have specialized construction courts. I mean, why? Because I think the courts itself realize that we need this speciality to resolve this problem. You know, how are we going to sort this out? We have to have specialized people dealing with this kind of thing. And I expect the lawyers will be the same, but I expect more importantly is the people who are doing the work and the professionals, they should also have that. So I think the understanding, I would say, not buy my book, but I think we have to go even further up in the universities. I mean, I think the real place is the universities, and then the postgraduate courses, and then more importantly, workplaces. Workplaces, the employer must actually make an effort to encourage people to do and attend these kind of forums so that they have this actual knowledge, and most important, read the contract. A lot of people, you ask somebody, he says this is what the contract says. When you read the contract, it's something else. They're very, very convincing, you know. First time they're reading it, and then everybody sort of gets a shock, you know. This is what it says. Ask yourself, how many of you all have read a contract from start to end? I think just ask yourself, you know. And I think very few of us have done that. Thank you.
Can I just add one point?
Sure.
Even just this morning, our Chief Justice has mentioned the statistics in a construction court, right? So it's growing. And I think what I noted is that in the last 2 years, she mentioned this MCO, the cases have not gone down. The filing of construction cases have not gone down. So I think that gives you what's going on in town. Thank you.
Thank you, Justice Lim.
I actually want to add that I've had cases where witnesses are reading the contract for the first time and then realize that the contract documents that they're holding in hand are not complete. And I said, what happened to the, or they are missing pages. They're realizing it for the first time. And that is so telling. Perhaps it's a reflection of the reason why we are in this state.
Thank you, Justice Mary Lim. And we are actually almost towards the end of the dialogue session, but as a closing question, and we are actually running out of time, so maybe 2 to 3 sentences talking about the book. I'm going to start with Justice Mary Lim first. If you would like to pick an area of Datuk Sundra's book, which area would you pick? Maybe a short one.
I looked around this room. I must make this comment. I am so proud of the fact that there's such a young crowd here, and that is so telling. And you also must recognize the fact that there's such a lot of young talent. So that's not just in the editorial board, but the fact that these people are here because they love construction. They actually are so happy to dedicate the next 50, 60 years of their lives doing only this and nothing else. And that, I think, also means this, that you must pay for quality. And I think it is time to recognize that if you are in a mess and you pick bad contracts, it's because you have not picked the right counsel, the right advice, professional, and you need to pay for it. And you all must stop undercutting each other. You must respect yourself, respect that you are quality, and this is your value. So the question is, and I come from a generation where we have a book called The Telephone Directory. A lot of you may not know of such a book. It's called a telephone directory. It's a directory of all telephone numbers because you all don't have house phones anymore. And there is a section at the back that used to be called Yellow Pages. And you'll walk through and be able to find whatever you find. And that's the thing I like about this book, that when I want to find answers and comparisons, I flip over. In the tort area is Camp and Camp, a book on Camp on damages. And that's what I like, the fact that I can look at it. And I wish I had this book when I was agonizing about the comparisons that I had to deal with. So I like the chapter that then gave me options, and I could walk my fingers through. And then if I wanted in greater detail, I could look at the PAM contract and find those other answers. So congratulations, Datuk Sundra. And thank you.
Thank you, Justice Mary Lim. How about you, Justice Lim Chong Fong? Just pick one area and...
Yes, just a short advice. Read the time obligation chapters. I think from my experience, that's where the disputes are always centered. So that's the clue for you.
Datuk Sundra, how about you? If you would like to pick just one area and a short one.
I think the most difficult chapter that we had was extension of time. And actually, I just realized after doing the extension of time, all that was for the benefit of the employer. You know, everybody is thinking the extension of time is contractors all will look at the, but you know, the entire setup is for the benefit of the employer, and even the employer doesn't realize that. So hence we had to actually go. I think it's the longest chapter, and we had to tie it back with completion. We had to tie it back with non-damages for non-completion. So I think have a look at that if you have a chance, because I think it was we have done it as reasonably as we could. Thank you.
Thank you, Datuk Sundra, and thank you, Datuk Mary Lim, and also Datuk Lim Chong Fong, for sharing generously on your views on the standard form of building contracts. And we are now moving to a very exciting moment, the book launch ceremony. I would like to invite all of you to remain on stage, and we will walk to the LED screen behind us while they are going to move the sofa away. At the same time, I would also like to invite Ms. Dewi Radin Amir, the Senior Director, Product Management of LexisNexis, to also join us on stage for the official book launch ceremony. Please welcome Ms. Dewi Radin Amir. And the book launch ceremony will start by placing your palm on the screen behind you on my count of 3. Are we all ready for the book launch? Are we all ready? All right. Let's put our palm after my count of 3. 3, 2, and 1. Ladies and gentlemen, Datuk Sundra Rajoo's book, Standard Form of Building Contracts Compared, is officially launched. It is truly our honor to witness this historical moment with all our attendees in AIAC Auditorium, as well as virtually on Zoom, LinkedIn, and also Facebook. Congratulations again, Datuk Sundra. And once again, I would like to ask all to remain on stage. Ladies and gentlemen, as we have now officially launched Datuk Sundra Rajoo's book, Standard Form of Building Contract, I now invite Datuk Sundra Rajoo and Miss Devi to give the token of appreciation to Justice Mary Lim and Justice Lim Chong Fong. Thank you, Justice Mary Lim, and Justice Lim Chong Fong as well. And may I now invite the special contributors of the book, Mr. Lam Wai Lun, to join us as well on stage to receive the token of appreciation from Datuk Sundra and Miss Devi. It is regret that our another special contributor, IR Habans, cannot with us today. Congratulations. Let's all come forward and we will have a photography session. Datuk Sundra, may I please request for you to stay a little bit longer on the stage, and thank you once again, Ms. Devi, Justice Mary Lim, and Justice Lim Chong Fong, and also Mr. Lam Wai Lun. We would like to take this opportunity to express our gratitude to all of you for gracing us today with your presence. With now, I would like to invite the editorial board member of Standard Form of Building Contracts Compared to come on stage to receive the token of appreciation from Datuk Sundra. The editorial board members are Ms. Heather E. Jinghua, Lee Kai Jun, Nawin Siri Kanta, Leong Chi Weng, Samira Hassan, James Teng Si Wen, Ashley Ui Hui Ying, and Ankit Shangwi, and also myself, Ng Chu Yin. This is in fact our very first time of meeting each other in person after for so long. This is Mr. Nawin. This is Samira Hassan. This is Ashley Ui Hui Ying. This is James Teng Si Wen. This is Ankit. And also myself, Ng Chu Yin. We will now be in a photography session. Thank you so much for all the editorial board members. And I understand now that Heather and Kaijun would like to go back to the podium to MC the rest of the session. And we would like to take this opportunity to thank you, Datuk Sundra Rajoo, for allowing us to be the editorial board members and also to present at this book launch. Thank you so much, Dato. I will now pass the floor back to Heather and Kaijun.
Thank you, everyone. We have come to the end of our book launch ceremony. We also take the opportunities to invite the book launch ceremony guests to join our standard forms of buildings contracts forums today. Our panelists and moderators will compare construction clauses in various standard forms of buildings contracts. For those who have not registered yet, you may register yourself with our registration team at the lift lobby.
Ladies and gentlemen, we are very proud to announce that we have more than 600 participants attending our book launch event virtually from Zoom, LinkedIn, and Facebook. We will now take a break. Before we kickstart our ladies and gentlemen, please stay tuned and come back at 3:30 p.m. We will have a giveaway at the end of our session. One lucky participant of the forum, whether you're attending in person or virtually, can bring home one copy of the Standard Form of Building Contracts Compact authored by Datuk Professor Sundra. Thank you so much.